Hello and welcome back to another episode of I'll Allow It Nevada, your go-to podcast for insightful glimpses into the Nevada judiciary. In this episode, we're shining a spotlight on the Access to Justice Commission, what it is, why it matters, and how it's working to close the justice gap in Nevada. I'm joined by Brad Lewis, director of the Access to Justice Commission, to talk about the commission's mission, its impact, and the initiatives underway to ensure all Nevadans have meaningful access to justice. Brad, thank you very much for joining me today.
Thank you, Seth. Glad to be here.
So to get the conversation going, tell me about the Access to Justice Commission.
Access to Justice commissions were starting to be formulated throughout the world and throughout the United States before we had an Access to Justice Commission in Nevada. And they started being kind of effective. And so in June of 2006 was the enabling order that allowed the commission to become a permanent commission in the state of Nevada. Interestingly, I actually am an employee of the State Bar of Nevada. Although the commission was formulated by the Nevada Supreme Court, technically our name is the Nevada Supreme Court Access to Justice Commission, and I report to the co-chairs of the commission, but I'm an employee of the State Bar and I get paid by the State Bar. So that's just a little bit of background on that. But commissions started to be a way to improve the ability of people to get a fair outcome in court with their legal matter. And so that's how we began. The founding co-chairs were Justice James Hardesty and Justice Michael Douglas. A lot of people on the call probably recognize those names. And through my early tenure here, they were the co-chairs of the Access to Justice Commission. The current co-chairs are Justice Christina Pickering and Justice Lydia Stiglich. And everyone's been terrific all along the way, great to work for, and really care about access to justice, making sure everyone has a fair shake, which is really what the commission works on all the time. You know, a little bit about the formation, because people ask me about that. The commission has, it's under SCR 15, which for the general public, SCR means Supreme Court Rule. SCR 15 is where the commission was established. That's part of the enabling order. And it lists who will be on the commission. So it's very prescribed who will be on the commission. And we have certainly judges. We have representatives of legal aid providers. We have legal community members. We have attorneys. We have non-attorneys. It tends to be very prescribed. For example, we have someone always from the 8th Judicial District Court, which is Las Vegas. We have someone from the 2nd Judicial District Court, which is in Washoe County. We have someone from a rural court. Currently, we have someone serving from Elko. And so there are also other little things like there will be someone from the Washoe County Bar, someone from the State Bar of Nevada, someone from the Nevada Bar Foundation. And so we are very prescribed to who we have on the commission, but people do rotate in and out. And if anyone's ever interested in the commission, we do have flexibility about adding people, but that's, you know, who it consists of from the community, about 25 people that actually sit formally on the commission. Technically, most of the work of the commission gets done through the committees. So there will be little committees that are pulled off to the side that really work on a problem that we have. Try to tackle it, bring that back to the commission. It's typically worked on again before at some point it's brought forth to the commission and typically advanced to a vote for an ADKT or some other action, which is an administrative docket for people who maybe aren't in the judiciary, or some other methodology that we use to move forward on the issue at hand. So that's kind of how we move forward. I also always like to lay a little bit of the land with people because certainly when I tell people I work for Access to Justice, quite frankly, a lot of people don't know what that is. Certainly the judiciary knows, but for the non-judiciary on the call, you know, if you think about it this way, if you are accused of a crime, an attorney will be appointed for you and they will represent your rights. And the reason that is how we do it is because it's potential that your freedom would be taken away. That isn't true in civil cases, which is what legal aid focuses on. Legal aid does not focus on criminal cases at all. It's only civil cases, so non-criminal cases. And But a lot of times, those are the very most important things that are happening in your life. It might be your mother, it might be your child, it might be your home is being foreclosed on, or any number of civil legal issues that need to be addressed. And so they're really important to people. And yet they have no attorney, and they may have great difficulty of pursuing that within the legal system on their own. So access to justice tries to provide ways that any average person, even if they don't have a lawyer, can get a fair outcome with a legal matter that they have. And that's kind of the focus of the commission. Another thing that people might not know is that it is income focused, what legal aid can help with. Certainly, if you can afford a lawyer, you probably don't have any problems. You're still going to have your legal issue, but you'll have a competent person that knows the law and can help you. But if you can't afford a lawyer, and so legal aid is funded to help people at or about 125% of the poverty line, up to about 200% of the poverty line. So just to give you an example, in 2025, the poverty line and a federal poverty line is $15,650. So not a lot of money. Obviously, 200% of that is about $30,000. People that probably don't have enough extra money to be paying for an attorney. So Access to Justice is working on things that can help them access the legal need help that they need. And that's kind of a parameter that's critical to legal aid. It's not available to anyone, and even people to whom it is available, the resources are limited. Not every person could be helped, but certainly legal aid organizations are very good at triaging, the most important legal issues where people really do need help. Now, I talk about legal aid a lot. What are the legal aid organizations? In Nevada, we have 5 legal aid organizations. We have Legal Aid Center of Southern Nevada. That works for Clark County legal issues. We have Nevada Legal Services. They're the only statewide provider, and they are the only provider in Nevada which is funded by the Legal Services Corporation, what we refer to as the LSC. In Washoe County, there's the Northern Nevada Legal Aid. And then we also have down in Clark County, the Southern Nevada Senior Law Program. The interesting thing about that program that's a little bit different of what I've talked about so far is they target people 60 plus, and because of some of their grants, they cannot discriminate on the basis of income. Still, most of the people who they work with are about at the poverty or below the poverty line. And then the final group, the smallest organization in Nevada, but a mighty one, is VARN, the Volunteer Attorneys for Rural Nevadans out of Carson City. So all of these organizations work together under a statewide service delivery plan to eliminate overlaps and focus on who can handle what in what region and really help people who need it. So I think a couple final points just in terms of laying out the lay of the land here. Our recent Nevada study of legal needs and economic impact found that in Nevada, 76% of people with a legal need can't afford an attorney and basically go without help. Nationally, a survey has been done which says that can be from 80% to 85% to 90%, and even 92% is the highest that I've heard of the number of people who have a legal matter but can't afford an attorney. So it's a lot of people out there. It's been growing. There are more legal matters and more people who can't afford to pay for those legal matters. And so that's just the reality of the situation. Probably the easiest way to think about that is that there's one legal aid attorney in Nevada for every 6,000 people in Nevada, but there's one private attorney in Nevada for every 400 people in Nevada. So there's a big discrepancy. The people who can afford a lawyer and potentially their outcome, although we want outcomes to be the same for everyone, and that absolutely is the intent of the court system. Sometimes that's hard to achieve without a little bit of support, a little bit of self-help, a little bit of guidance, a little bit of help with forms and that type of thing. So that would be kind of my general overview of the sort of the genesis and the lay of the land of the legal aid system and access to justice in Nevada.
Those are some very interesting statistics. So, to what extent do you think the judiciary the overall judiciary knows about these statistics?
Well, they certainly know the problem, and they probably know it better than I. Whether they know actual details of statistics or not, I don't know, but they know the numbers aren't great. But I think that the statistics do help to frame, what a large problem it is. In Nevada, for example, one of every three people technically qualify for legal aid in Nevada. So we do have a fairly high poverty threshold in the state of Nevada, and all those people could theoretically need help and access help through legal aid if there are the resources to support them. I guess the other thing I would say, the judiciary knows most of these things, but one of the things that I think is important to remind people is that within our system, it's believed that some of the cases are really so critical and so important that counsel is in fact appointed. In Nevada, we had a major problem with our guardianship system. And so now all adult guardianships statewide are automatically provided an attorney to make sure their rights are protected so that someone basically isn't, putting them in a location and removing their assets in an unethical or inappropriate manner. Also, most children in foster care are represented in the courts. And in Clark County, Legal Aid Center has a contract to represent all children in guardianship. And so, even within the law, within the funding which can be found, there are matters, civil matters, that have been determined to be so important that an attorney will be appointed. And so I think the judiciary is familiar with these things and sort of the growing need for contracts from legal aid to really help with some of these areas. And then we, address it in other ways as well. That's kind of the basics, I would say.
Hi, everyone. I hope you're enjoying this episode of I'll Allow It Nevada. We're always striving to bring you valuable insights and education, not just for judicial officers, but for anyone interested in the Nevada judiciary. If you find our content helpful or intriguing, please share your experience with your friends, family, and colleagues. Your support helps us reach a broader audience and ensures more people can benefit from our discussions. Thank you for listening and supporting I'll Allow It Nevada. Can you give us some examples of legal problems that are seen?
Yeah. And certainly the judiciary knows about these problems, and some of them are quite horrible. The general public may be less aware. I'll give you a couple examples. One, everyone remembers COVID, of course, but during COVID, the Access to Justice Commission operated the eviction mediation program in Nevada. You may recall during COVID, there were huge dollars that were available for rental assistance because a lot of people were, especially in Nevada, were unemployed. We had as many unemployed in Nevada during that time during COVID as were unemployed during the Great Depression. It was definitely a crisis, especially in Nevada. But there was funding to provide rental assistance. And so the eviction mediation program in Nevada was set up to do that. And that would be a typical thing that the Access to Justice Commission would get involved with. Anyway, an example, and so I saw a lot of it is these stories can be very long, so I'll keep it short and sweet here. But one thing we saw, for example, was children stealing rent money from parents, and so senior citizens were not able to pay their rent, and then were thrown into an eviction process. That was one example they saw. Horrible, but these real life things happen that are bad, are true, and unfortunately they happen every day. Another one, there was a woman who was living in a Siegel Suites, who had just given birth via cesarean section, but she was getting evicted from Siegel Suites. But she was really suffering, probably should have been in a hospital and was bedridden, but being evicted from a Siegel Suites. And so we had mediators who, helped her stay in that location until she was well enough. And of course, was facilitating, the mediators were facilitating this major federal rental assistance, getting the landlords paid for these instances. And, the one that I've always really tugs at my heartstrings are the veterans, particularly the ones that tend to be somewhat mentally challenged in whatever way. not getting the benefits they deserve, whether they're housing benefits or healthcare benefits or a number of other, a panoply really of services that are available to them. But they really just don't have the capacity to manage and handle accessing those services. Legal aid is a godsend for those people, and there's some terrific stories of moving people off the street into secure, safe housing and really getting people the assistance they need. So without getting into a lot of detailed stories, I'm sure the legal aid providers will provide great stories, but those are just some examples of the type of civil matters that you see. They're really crucial that someone take care of in sort of emergency triage situations.
So you had previously mentioned Supreme Court Rule 15. Part of that, I see there are 6 charges for which the commission is responsible. I thought we could maybe just touch on each of those real quickly just to give the listeners some context and provide a bit of color. The first
Sure.
is assess current and future civil legal needs. Tell me about that.
Right. Assess current and future civil legal needs. So that's critical, of course. A lot of statistics we provide come from the legal needs study. The most recent one that we conducted was completed formally in 2018. Prior to that, there was a study done shortly after the commission was organized in 2006. The study was completed in 2008. So about every decade, we're maybe approaching a time that we need to do it again here. But that's where certainly legal aid, for example, knows what walks through the door. Judges see the kind of problems that walk through the door with self-represented litigants. But what are we missing? How does it look by county? What type of populations are affected? That type of thing. That's the type of information we get from the study. In fact, if there's any judiciary or just members of the general public that are interested on our website, and we'll talk about that with the URL later, but you can find the legal needs study and you can actually go in and look, like if you're in one county, what's your main problem? Is it a family law problem? Is it probate problems? Those problems will be listed. And then the legal service providers are able to take that into account as they design their services for throughout the state. So that's just an example of the one study that we've completed previously. I mean, another example is the Nevada IOLTA study. Interest rates have been increasing after a period of, virtually zero interest rates for a number of years. Interest rates have been increasing over recent years. And so we wanted to make sure the Nevada IOLTA program was keeping up. And so we looked across the nation, regionally, here in Nevada locally at our adjacent states, what's happening? What rates are banks paying for IOLTA accounts and that type of thing, just so we're making good decisions and being good stewards of potential funds that can help to fund legal aid.
Okay, and for the second charge is develop statewide policies to improve legal service delivery. Can you expand a little bit?
Right. So we always want to be improving legal service delivery. Sometimes we can do that on our own, and we do. Certainly, there's been great work on the self-help front. But sometimes policies and potentially even rules, legislation, which we'll talk about later, but need to be adjusted. And so we have worked on a number of these things. And just to give you some examples. So not too long ago, we did a supervised practice for law school graduates. Prior to this rule that has now been implemented, if you had graduated from law school but not yet practiced, or excuse me, not yet passed the bar, you were unable to practice law, which would make sense, right? But before people find a job, and sometimes there's a wide amount of time that people have, then they could help someone, or maybe they could volunteer or serve in a paid capacity with legal aid until they find a job. And so this rule of supervised practice for law school graduates before they pass the bar really has added, service capacity to legal aid in Nevada. And it's not only available to the legal aid providers, but it's also available to the DAs and the public defenders, the district attorneys and the public defenders. And so, one of the things we want to do is address the justice gap. This is a way to help address the justice gap. So that's one example. Another example is we heard complaints from retired inactive attorneys that they were being required to get so many hours, 13 hours, which is what everyone is required to do, which of course is reasonable. But just to take a pro bono case, once a year or once every couple of years. And so we worked on a rule for people who are retired, they have to be retired, inactive, they have to be inactive, and they have to be enrolled in the Emeritus Attorney Pro Bono Program. So for those of you in the know, that's 49.1. Um, and the point is there's a lower barrier now specifically for these people only to provide pro bono so that more clients can get help. It was believed that that made sense, certainly because pro bono is so necessary, and we don't want to turn away the most experienced people who are willing to volunteer. But people do need to be up to date. But in the case of when they're working through a legal aid provider, they're getting CLE, which are poverty law CLEs, directly from legal aid providers, and then they're being supervised by legal aid attorneys. So it's the perfect, unique situation to allow additional service for people. So again, a rule that we worked on to change that really helps increase the availability of services for people who could not otherwise afford it. Another example, in Nevada, the peremptory challenge fee was $450, which is really quite high. We did a study that showed it's the highest, in fact, when we did our study of any state, with a lot of them being zero or very low cost. So one of the changes that we did make is that for people with a fee waiver, they've already been approved for a fee waiver, or people who are clients of legal aid. So again, they've already been pre-qualified. They can basically have the fee waived, the $450 fee waived for a peremptory challenge. Now, we don't expect this to be used a great deal, but there are certain fairness issues that if you can afford an attorney, you shouldn't be able to make a challenge that if you can't afford an attorney, you can't. So on basic fairness, we're always looking for those issues and trying to make them where they make sense and are fair for everyone. I mean, I have a lot of these examples, but the last one I'm going to use is the informal family trials. You may or may not have heard of this, but it's the District Court Rule 27, which is currently in a pilot program. It expires November of this year, November of 2025. But basically, it's a simplified trial um, uh, only when allowed by the judge and when approved by both parties, to reduce the rules of evidence to make it the judge be able to answer or ask pointed questions, which without being directed or being favoring one client or another can really help move people along. I mean, this type of thing, it really was happening with self-represented litigants already. This is a formal framework. The pilot has been going well. Certainly, the main thing we've heard is the SRLs, SRL being self-represented litigants, are more comfortable understanding and navigating the courtroom when these informal practices are in place. The judge hears information, even if the precise evidentiary rules aren't followed, and self-represented litigants don't know when to make a motion or the details of evidentiary rules, etc. But they need to be heard, and judges, of course, in these cases are allowed to let a self-represented litigant be heard, and everyone is looking for a fair outcome. But this informal family law trials, I think, is a great pilot, trying to help more real people. These 80% of the people now who are going into family law court on their own without an attorney. So those are some examples on some of the policies that, when we make these tweaks and we try to work through the commission's committees, and all these have happened probably in the last couple of years. And we didn't do informal family trials on our own. That was done through a separate, but the commission did support that because we believe in what they're doing and we wanted to be supportive of this pilot project.
And if any listeners are interested in learning more about the informal family law trials, I would encourage you to listen to our episode on it with Judge Gregory Gordon. A heartfelt appreciation to our guest and to everyone who has tuned into this podcast. Before we wrap up, here are a couple of quick, important reminders. For continuing legal education credit, be sure to complete a certificate of attendance and email it to jepodcast@nvcourts.nv.gov. If you have any questions, topic suggestions, or comments, we welcome your input. You can email us at jepodcast@nvcourts.nv.gov or submit your topic ideas through our topic suggestion form linked in the episode description. We value and look forward to hearing from our listeners. Stay tuned for more episodes of I'll Allow It Nevada. This is Seth Easley signing off. Take care, Nevada.